Hi everyone, my name is Isabelle Jung. I'm a trademark and copyright attorney at CRGO Law in Boca Raton, Florida. So today I'm going to talk to you about trademarks and basics about trademark law and what you need to know in order to protect your trademark in the United States. So first, what is a trademark? A trademark is a word, a design, a combination of both. In the trademark world, we talked about either word marks versus design marks. That's a fancy word for logos. So what is the purpose of a trademark? So a trademark helps to identify the source of the products or services of a company from the source of the products and services of another company. And very importantly, trademark rights only exist in the United States if you are using your mark in commerce. What does that mean? It means that you have to use your mark if you're selling a product on the product itself, or if you're offering a service, you have to use your mark in the advertising of your services. There are three basic trademark signs that you will see that are used to refer to trademarks in general. There's what we call the TM sign, and the TM sign refers to a trademark that's not registered with the trademark office that you use in connection with a product. So you will affix that TM sign right next to your trademark. The second type of sign that you will see for trademarks is the SM sign. And the SM sign is used for a mark that is used in connection with a service. So you will once again affix your SM sign right next to your mark in the advertising of your services. So these two signs are used only if your mark is not registered with the Federal Trademark Office. If you happen to have a registered trademark with the Federal Trademark Office, then you will be able and allowed to use the circle R sign. And once again, you want to put that circle R sign right next to your trademark so you can give notice to customers that you own a trademark and whatever precedes that sign. Putting the circle R sign is very important because it allows you to also collect what we call statutory damages, that are damages that are provided by law. So before we file for a trademark with the Trademark Office, we want to determine if our mark is even worthy of protection. And that will be a two-step analysis. The first step of the analysis is we need to determine if our mark is distinctive enough to receive protection. So the courts in the US have determined a spectrum of distinctiveness for marks. At the lower end of the spectrum, you have what we call generic marks. And a generic mark is a mark that is exactly what it is you're selling. For example, if I wanted to have headphones as my mark and I'm selling headphones. So that is not a protectable mark. The next step in the spectrum is what we call descriptive marks. So descriptive marks are what it is. They're descriptive of what it is you're selling as a product or as a service. So for example, a talking machine for a telephone. So that would be a descriptive mark. In general, descriptive marks are not protectable unless they acquire secondary meaning. And secondary meaning is something that's hard to get, and it only happens when you're able to prove that customers associate your mark with you. But as a general rule, descriptive marks are not protectable, so you want to avoid them. So right after descriptive marks, we're going in the spectrum to what we call suggestive marks. Suggestive marks suggest an element of what it is you're selling. For example, Greyhound buses for use in connection with buses. It would be suggestive because you have the word Greyhound that suggests speed, but it is not descriptive either. So you can get protection for a suggestive mark. Another step up in the spectrum of distinctiveness are arbitrary marks. Arbitrary marks are like Apple for computers. It's a mark that has no connection with what it is you're selling, and it is therefore a very strong mark. So looking at that spectrum of distinctiveness, you have to determine where your mark is, and is it at the lower end or upper end of the spectrum, and then you can know if you have a strong mark. So once we've determined if our mark is distinctive enough to be protectable, we're going to go to step 2 and determine if there is another mark out there that would be too similar to our mark and would be an impediment to the registration and even use of our mark. So here we're going to apply a test that's called the likelihood of confusion test, and that's a test that's been created by case law in the United States. When we do the likelihood of confusion test, we always put ourselves in the shoes of the customer. And the question we ask ourselves, that's the biggest question, is the customer likely to be confused as to the source of product number 1 and the source of product number 2? If the answer is yes, then we have a problem. There's different factors we're going to look at when we compare marks to determine if there is a likelihood of confusion. Obviously, we're going to compare the marks next to each other. We're going to look at them from a sound perspective, a connotation perspective, the commercial impression they're giving. So it's not just a basic comparison of the marks. We're also going to compare the goods and the services sold by both parties to see if they are similar, and a customer could be confused as to the source of your product versus somebody else's product. And we could also look at the channels of trade. If your product is sold in a grocery store, for example, and your competitor product is also sold in a grocery store, there could be a problem with that. After looking at all those factors, if we answered yes to most of the questions, meaning yes, both marks are similar, yes, we're looking at similar type of products or services, or yes, we have similar channels of trade, then we may have a problem and a risk of proceeding with applying for a mark and even just using our mark. Because that likelihood of confusion test we just talked about, that's a test that we apply at the trademark office level to determine if you can register your mark, but it's also a test that is applied in court when we have a trademark infringement action. So now that we looked at the two-step approach, we first determined that our mark is distinctive enough to get protection, and also there's no other marks out there that we found that similar to our mark, then maybe we want to move forward and apply for a trademark with the Federal Trademark Office, that's also called the United States Patent and Trademark Office, USPTO. One thing you need to know, though, is in order to apply for trademark protection with the USPTO, you need to have interstate trademark use. What that means is you have to use your mark in multiple states. So if you're selling a product, you have to sell your product in multiple states. If you're offering a service, you have to offer your service in multiple states and not just one state only. If you are only using your mark in one state or one particular geographical space, let's say I sell my products in Boca Raton, Florida only in one store, or I have a massage parlor in Boca Raton, Florida, and I only offer the services in that particular city, then I will still have trademark rights. They will be called common law trademark rights. But they will be limited to that particular geographical space. And I will not be able to prevent somebody from using a similar mark to mine and being in a completely different geographical space, in a different state or just different city. So that will wrap up our presentation today on the basics of trademark law. We looked at whether your mark is worthy of protection and how it could be protected. And I welcome any questions that you may have. Thank you.